with our webinar series, Decoding of IBC, Important Judgment under IBC of last 15 days, including Disciplinary Committee Orders. Friend, this series we have started, basically IBC is now more governed by the decided cases, and each IP, lawyers and all the people who are concerned and affected by IBC should know what is going on as on today. And it's very complex situation, and that's why we have started this series, and we hope that the same will be helpful. All the participants, we try to make it interactive. We'll try to request you to put everything in a chat box, whatever your query. If required, the panelist or we will allow on raising of your hand to unmute and say the whatever you want to discuss. During the presentation, panelists will give their views and any suggestions or their inputs or expert comment. Today's our panelist, we have with us Advocate Anirudh Purushottam. And I must say, with Anirudh, I share a very personal relation because I have given my many cases, and we keep on discussing various issues of IBC, and I can say we have learned IBC together, right, Anirudh?
That is very kind of you, madam, but we learned it from you also.
No. So thanks, Anirudh, for your time. He is very busy. Friends, certain cases, what we referred, even I was not knowing because this PPT was prepared before. And then I realized that it was represented by Anirudh only. So we have with very eminent lawyer, Mr. Anirudh, who has also represented some cases in today's discussion we had. So, and we
Hello,
have
everyone.
Mr. Anirudh Purushottam is a proprietor of Lex Legal Corporate Law Advocates, and he is also practicing. He has completed graduation and law from Bangalore. He is also employed as an advocate with Aditya Birla and Belf Invest. He is practicing law over 5 years at Mumbai with versatile experience of working with law firms, audit firms, practicing chartered account, company secretary. He has rich experience in taxation, audit, corporate law, litigation, and property rights, labor law, you name it, many things. It will be long list, but especially is practicing and is expert in insolvency, I will put that way. Welcome, Mr. Anirudh, to this webinar. Thanks for your time.
Thank you, madam. Good evening, everyone.
Yeah, we have with us Mr. Devendra Umrao. Mr. Devendra Umrao graduated BCom honors from University of Delhi, then lawyer from National Law University Delhi, with specialize in banking and insolvency law. Is also masters in business administration, specialized in finance, and have more than 25 years of managerial experience in the field of corporate finance, banking, factoring, having domain knowledge in NBFC, factoring, compliance, banking, and he has dealt with various banks on various assignments, and he was also dealt with IFCI Factors Limited, and he has having financial institution experience with over 35 African countries. He has having experience over various years. He is also IP, and he is also taking cases, and he also is having very versatile experience in finance, taxation, management, and insolvency. Welcome, Mr. Devendra.
Thank you, ma'am. Good evening, everyone.
Good evening. And important thing is the associate partner of Mehta and Mehta Insolvency Restructuring LLP, and located at Delhi. Thanks, both of you panels. We have with us Ms. Urvashi Sathe as our presenter today, and we'll start the presentation. Thanks, Ms. Urvashi. You can start the presentation. Panelists, you can give your views in between as and when you want. And participants, you can put your questions in chat box as and when you want. Thanks. Urvashi, you can start.
Yes, ma'am. Good evening, one and all. So today I'm here to present recent important judgments under Insolvency and Bankruptcy Code 2016. SVA Family Welfare Trust and others versus Ujas Energy Limited and others, whether personal guarantee given to financial creditors can be extinguished in a resolution plan. The order was passed by NCLAT New Delhi on 21st August 2023. Facts of the case: this appeal has been filed against the order passed by the NCLT indoor bench, by which an IA filed by the resolution professional for approval of resolution plan has been rejected. Adjudicating authority took the view that COC cannot extinguish right of particular secured creditor to proceed against the personal grantor of the corporate debtor. Hence, the plan contravenes the provisions of Section 32E of the Code. The appellant, who was successful resolution applicant aggrieved by the order rejecting his resolution plan, has come up with in this appeal. The only question which arises for consideration in this appeal is to whether the resolution plan can there be a clause which proposes the extinguished security interest of financial creditor by way of personal guarantee of directors of corporate debtor, which was given for obtaining financial assistance from the financial creditor. Decision of the appellate tribunal: the adjudicating authority committed error in rejecting the application of approval of the resolution plan on the ground that the plan could not have contained a provision for
Extinguishment of.
extinguishment of personal guarantee for personal grantors. Plan allocates a plan value for extinguishment of personal guarantee, which has been accepted by the financial creditors by a vote share of 78.4%. The order of adjudicating authority dated 6 January 2023 is unsustainable. In result, we allow the appeal and set aside the order dated 6 January 2023 passed by the adjudicating authority. The resolution plan submitted by the appellant did not contravene any of the provisions of Section 32E of the Code. The adjudicating authority shall proceed to pass a fresh order in IA 190 of 2021, praying for approval of the resolution plan along with the necessary direction. The adjudicating authority shall endeavor to pass fresh order on IA 190 of 2021 within a period of 3 months from the date when the copy of this order is produced before it. The appeal is allowed accordingly.
So
Yeah.
participants, this is a game changer. For all we know, this question has not been answered so categorically. Until very recently, NCLT indoor bench came up with a pronouncement that no resolution plan can deal with extinguishment of a personal guarantee. Because the common understanding is that a resolution plan can deal with only the CIRP estate in that sense. So as per 18 subsection 1 subclause F of the code, an RP is supposed to take custody and charge of the assets of a company. A resolution plan can only deal with assets of such company and not with any assets outside that of a company. So then in fact, the origin is from the Lalit Jain judgment, wherein the Supreme Court, while upholding the constitutional validity of the provisions of personal guarantee, made a passing remark that a resolution plan cannot ipso facto, to use the very words, ipso facto extinguish the personal guarantee by operation of law. And this led to various interpretations in one way or another until the NCLT indoor bench came up saying that we cannot do it. In fact, even NCLT Mumbai, by relying upon the NCLT indoor bench judgment, have rejected a resolution plan. To be very particular, it is NCLT courtroom number 5. And in fact, such matter is also pending before Honorable NCLAT. So now this lends us the much much wanted clarity on this subject. So, however, it has to be seen in what circumstances a personal guarantee can be extinguished by virtue of a resolution plan. So, in fact, this judgment also speaks that there must be some consideration which should be assigned to the creditors qua this extinguishment. Reason being that the financial creditors are giving up on their personal guarantee. So then there must be some consideration prescribed for the same. This is one. And two, the discussion as regarding the extinguishment of personal guarantee must have been categorically addressed and extensively discussed in the Committee of Creditors meeting so as to lend it the sagacity of a commercial wisdom. So according to me, these are the important facets to be seen whether a resolution plan can extinguish a personal guarantee.
Yeah, Mr. Devendra, you have any comment?
Yeah, in fact, ma'am, I was coming to the consideration only that under what circumstances, as Advocate Anirudh has rightly pointed out, so these two points have to be taken care of and duly recorded. Of course, the plan will obviously come in the plan, but as Advocate Anirudh has pointed out, the discussion and deliberation on this point should also happen to give it, sanctity of having been discussed and commercial wisdom being imparted to it. So I think this is what one can derive from this judgment, that if these two essential criterias are met, then yes, this can be considered, extinguishment can be considered
In the
based on,
resolution plan.
yeah, in the resolution plan.
Very important game changer, as rightly said, this is the resolution.
Absolutely, ma'am. There was
Absolutely.
a lot of haziness around this
Yeah,
earlier, but at least there is a light now. You're right.
yeah. Yeah, please go ahead, Joshi.
Mr. Joshi, Director of Khadereshwar Hatchers Limited versus Axis Bank Limited. Corporate debtor cannot avail benefit of Section 10A of IBC where the date of default prior to 25th March 2020 and OTS proposal was withdrawn during CIRP suspension period. The order was passed by NCLAT New Delhi on 18th August 2023. Facts of the case: on account of default committed by the corporate debtor, the account was classified as NPA on 19/7/2016 and OTS proposal was submitted by the corporate debtor while letter dated 4/12/2019. OTS proposal submitted by the corporate debtor was sanctioned by the bank while letter dated 4/2/2022 for outstanding dues of rupees 12 crores 80 lakhs 11,496. Bank agreed to settle the outstanding dues at 5 crores. The corporate debtor on 13th March 2020 sought for modification of repayment schedule. Corporate debtor subsequently, via letter dated 25th January 2021, withdrew its OTS proposal. Decision of the Appellate Tribunal. The OTS was accepted prior to the commencement of Section 10A period. From the letter which was given by the corporate debtor on 13th March 2020, which has been brought on record along with this appeal, it is clear that the corporate debtor committed default of the OTS even before 25th March 2020. The submissions that since default was also committed by the corporate debtor during the Section 10A period of the OTS amount, which ultimately withdrawn on 25th January 2021, the application should be barred by Section 10A does not commend us. There being categorical default by the corporate debtor prior to Section 10A period, the appellant was not clearly entitled for benefit of Section 10A period. In the view of the foregoing decision, we do not find any merit in contention of the learned senior counsel for appellant that the application under Section 7 of the Code 2016 was barred by Section 10. The adjudicating authority did not commit any error in admitting Section 7 application. There is no merit in the appeal. The appeal is dismissed.
In fact, some intriguing questions of law is raised in this appeal. In fact, I lost this appeal just last week. This was my matter. And what actually happened was that there was a default which actually happened during the 10A period. So initially there was a default which was prior to 10A. And thereafter, during the COVID situation, we were in the business of poultries. So the poultry business took a hit. So we sat across with the bankers and we arrived at an OTS with the bankers. And in fact, quite a bit of monies were also paid, and certain payment schedules were also duly honored during the OTS period. And after which, what then happened was there was a breach of OTS. Reason being that the COVID situation became more severe, thereby directly affecting the poultry business. And so there was a continuing default, and the debt could not be repaid. So when the bankers went to NCLT, we mounted a defense saying that the loan agreement which prescribes a payment schedule is now novated by virtue of an OTS agreement, which is now a contract of novation. And therefore, uh, now for all practical purposes, the contract between the parties is governed by the OTS letter. Now, if there is any breach of the OTS during the 10-day period, then Honorable Inclad deferred with us, and then passed orders by uh, laying down the proposition that even if there is a default during the OTS breach, one has to see when was the first default happened. If the first default is prior to the OTS and which is prior to the 10-day period, then 10-day will not get attracted. Thank you.
Thanks, Anirudh, for such a good explanation for this case. Thank you.
Thank you.
Yeah, so the conclusion, Advocate Anirudh, is that the original default, I mean, the first default will be the deciding factor whether 10A applies or not. I mean, this is what, right. Okay.
Yeah, right. Yeah, Joshi.
Yeah, ma'am. Peterbeck and Partners versus Sharon Biomedical Limited and others. Assisting financial creditors are entitled for payment as proposed in the resolution plan, and descending financial creditors is entitled as the minimum amount prescribed in Section 32B of IBC. This order was passed by NCLAT New Delhi on 14th August 2023. Facts of the case: this appeal has been filed by a descending financial creditor challenging the order dated 17/5/2023 passed by the NCLT Mumbai Bench Court 1, by which the adjudicating authority has allowed the application filed by the resolution professional for approval of the resolution plan submitted by respondent number 4. Learned counsel for the appellant has submitted that there cannot be any discrimination in the payment to the unsecured financial creditors on the basis of their assent and dissent. The legislative history of IBC and the amendments made therein indicate that legislature never intend any discrimination between one class of financial creditors. Decision of the appellate tribunal. NCLAT concluded that the ascending financial creditors for payment of as proposed in the plan and descending financial creditors is entitled as per minimum entitlement as per Section 32B. There is no dispute that the liquidation value of the appellant in the present case is nil. The submission of the appellant that there is a discrimination between the payment of ascending unsecured financial creditors and descending unsecured financial creditors cannot be accepted, and on the ground as urged by the appellant in this appeal, the resolution plan approved by the adjudicating authority cannot be held discriminatory. We thus are of the view that there is no error in the order of the adjudicating authority approving the resolution plan. There is no merit in this appeal. The appeal is dismissed.
Again, a defining judgment, in my opinion, ma'am, and Advocate Anirudh, because like the personal guarantee order, this one also puts to rest, if there is any ambiguity on this.
Financial security.
Yeah, assenting and dissenting financial creditors and their rights. So it has firmly held on to the provisions of IBC as are already enumerated under Section 32B. And they have said that this will prevail. No, there are no interpretations to that in either or manner for that. So I think it's very categorical and self-explanatory. Still, if participants have any queries or questions in this regard, we can take that.
Yeah. Any participants, any query or comment, then they can say, then otherwise we'll move ahead.
Normally, madam, the ratio which was so far followed was there must be equal treatment between the equal classes of creditors. So one might also argue that
Yeah.
whether they, despite them being assenting or dissenting, both are financial creditors, and therefore the same percentage towards their debt should be given in the resolution plan, because
Right.
these are not financial or operational. They are only one class of financial creditors. But this judgment is important because this says that even within financial creditors, there can be subclasses of creditors. So this is interesting, madam, because in one of our sugar mills case, there was 100% payment made to the farmers who are technically operational creditors. However, there was only 1% which is assigned to the vendors. So thereafter, we challenged the approval of such resolution plan, wherein Honorable Enclad said that no, there can be a different subclass within a class of creditors, and differential treatment can then be done. So I think same analogy is being given in this order also, wherein they must have said that in the financial creditor group, there can be a subgroup of assenting and dissenting, and therefore no same treatment has to be given, same percentage has to be provided. However, the minimum percentage as prescribed under law, which is
Yeah,
the liquidation
that
value,
clarity
given.
they have
That is
given.
not
So that is
negotiable.
very
Yeah.
clear. What
That
each
is very
one
clear.
will get, yeah. That is also very important clarification they have given.
Right.
Very
ma'am.
important, madam.
Though in
Very
the act
important.
it is written, but code it is written, but there are always here also fight and confusion.
Correct.
Right.
So
And
conversely, madam, for the assenting financial creditors in a different situation, there can be a value less than liquidation value also. Whereas for the
agreed.
dissenting, there cannot be a value less than the liquidation value.
Agreed. I was coming to that, Mr. Anirudh. In fact, I was saying this only that COC members, ma'am, are privy to the fair value and the liquidation value. So it's a judge. I mean, the decision to vote assent or dissent is not something taken in dark or in
Right.
in lack of information. So it is a conscious decision. So if knowing the provisions of the law, which are categorical and clear, when you know the liquidation value and hence you know what will come to your as your share, still if you decide to dissent or assent, then that is a decision you have taken knowingly. So I think NCLAT has held that the provisions will apply, and you should be aware that what your share is going to be if you dissent.
Someone has written in chat box what reasons were given by NCLAT for its order. I think one justification you already given, that is that it is very much clear in the code, and the value is known to the financial all the
Right. So it's a conscious decision you have taken, knowing fully well the provisions of 32B that you will get only liquidation value.
Yeah.
Correct. And also, yeah, for a dissenting creditor, minimum is prescribed, maximum is not prescribed.
Yeah.
Maximum is left to the resolution applicant and
Yeah.
the COC members.
Right.
The idea is that, according to me, there must be some security interest which is enjoyed by the dissenting financial creditors. So if at all the company goes into liquidation, then they were entitled to that security interest. So therefore, that minimum liquidation value of that should be given to them so that they are not deprived otherwise.
Right. There is another question. What happens when resolution plan without financial creditors being informed liquidation value?
I couldn't get this, ma'am.
Even
Actually,
I didn't get what happens
yeah.
when resolution plan without financial creditors being informed liquidation value. Mr. Vinay, can you unmute and say what is your question? Mr. Vinay? I think.
Or maybe he can.
Take it later. I
Yeah,
think.
we can put it on chat to clarify
Yeah.
further.
Urvashi, you started. Go ahead.
GS Constructions versus Mr. Ganesh Labchand Jain. Once the majority of COC decide on one resolution plan, the decision of COC attains finality. Unsuccessful resolution applicant has no locus to challenge the commercial decision of the COC. The order was passed by NCLT Mumbai bench on 11th August 2023. Facts of the case and submissions. The applicant, which is a proprietorship, had filed this present application challenging the authority of respondent number 2 to act as an authorized representative of the home buyers of the corporate debtors, opposing the approval of the resolution plan submitted by Mrs. Asha Sanap, challenging the illegal rejection of the applicant's resolution plan by the Committee of Creditors, being vitiated by the fraud perpetrated by some of the fraudulent home buyers and certain elsewhere directors, and consequently seeking reconstitution of the COC of the corporate debtors. The COC in its 8th COC meeting approved the resolution plan presented by Mrs. Asha Sanap by 79.60% voting, while the resolution plan submitted by the applicant was not approved as it failed to secure the requisite voting of members of COC. Decision of the adjudicating authority. This bench is of the opinion that once the majority of COC decide on one resolution plan, the decision of the COC attains finality. It is observed by the bench that in present case, since COC comprising of SIDBI and the home buyers approved the resolution plan presented by Mrs. Asha Sanap, the unsuccessful resolution applicant had no locus to challenge the commercial decision of the COC. It is observed by the bench that at no stage the applicant challenged the constitution of COC. The question of the some home buyers as fraudulent was also raised by the applicant after the plan of the applicant was not approved with the requisite voting of COC. The bench has further observed that the applicant has filed an application which was rejected by this tribunal on the ground of being a related party, and the said decision was also confirmed by the Honorable NCLAT in company appeal. Hence, the applicant has no locus to challenge the COC at this, when the COC has already approved the plan submitted by Mrs. Asha Sanap. Hence, the appeal was dismissed.
So this is an important judgment. In fact, I was for the successful resolution applicant in this matter. It's not surprising that it is said that unsuccessful RA has no locus to challenge the commercial decision. In fact, for that matter, even a successful resolution applicant, it is laid down that he does not have any stake unless his resolution plan is approved. Any stake in the sense that he has no skin in the game, or he cannot come to the court to assert certain rights of his unless the resolution plan is approved by the adjudicating authority. So likewise here it is said that unsuccessful resolution applicant has no locus to challenge. So the gist of this matter is that there were certain COC members, majority of which consist of SIDBI, which is a financial institution, and a set of home buyers. Like we are all aware, home buyers are represented through each authorized representative, whose vote is governed only by the majority percentage of the home buyers. So supposing if he is supposed to vote by 51% of the home buyers vote, then the dissenting vote of the 49% does not get recorded because he votes on behalf of entire 100% of the home buyers. So it was the case of the resolution applicant, resolution professional also here, on the basis of the transaction auditor's report, that there were certain transactions by the home buyers which are avoidable in nature. If those transactions are avoided or reversed or set aside, then it has a bearing on changing the percentage of voting. Because if a home buyer owes, for instance, is owed 10 lakhs by the corporate debtor, if these transactions are avoided by the Honorable NCLT by virtue of this PUFE transaction applications, then this 10 lakhs gets reduced to 7 lakhs. So therefore, there will be a proportionate reduction in the voting percentage. So all of this is keenly noticed and analyzed by the Honorable NCLT. In fact, during the oral arguments, it was also the court was also satisfied that even assuming all the applications are allowed and all the voting percentage are then proportionately reduced, even then the home buyer's vote may not be impacted because the authorized representative is supposed to act on the basis of the 51 percentage of the home buyer's vote. So, and moreover, all these challenges are raised only after approval of resolution plan in the committee of creditors meetings. So thus the resolution plan was approved. In fact, it was such a relief because there were so many avoidance and everything was ably and efficiently dealt with by our NCM. Thank you.
Thank you. Thanks a lot. Thanks for input. Yeah, please go ahead.
Timex Bond Industries Private Limited versus DS Industries Private Limited. An operational creditor is not entitled for interest in absence of any written contract between the parties.
1 minute, Urvashi. There is a chat in chat box, the question, because that is relevant because this was home buyer. Mr. Vinay Kulkarni has given in chat that Lavasa case. I believe the resolution plan has been passed by NCLT where home buyers are only 7% classified as financial creditors. So whatever they vote, the home buyers have no say in passing the resolution plan. The liquidation value was never communicated to home buyers but were asked to vote assent or dissent on resolution plans. Thus, where the home buyer does not know his liquidation value but has been forced to accept based on what other financial creditors who are 93% have voted. So, in that case, Mr. Kulkarni, what is your question? That resolution plan, we understand you've given the fact, but what is your question?
Madam, but this is what we all have to live with because whatever is the voting percentage, but of course the home buyers have that 7% skin in the game. They can tilt the voting percentage to that extent.
But
Supposing,
whatever is percentage, you have to deal with that.
correct. Supposing there is an financial creditor of 59%, then without the home buyers vote, the resolution plan can never get approved. If the other voting percentage, then if the other financial creditors then dissent. So it is always corresponding to the debt owed by the company.
Right. Okay, Urvashi, go ahead.
Yeah, ma'am. Facts of the case and submissions. This company petition is filed by MX Time Bond Industry Private Limited, seeking to initiate CIRP against MS Dietis Industries Private Limited by invoking the provision of Section 9 IBC for the resolution plan of unresolved operational creditors of debt of rupees 50,17,589. After disposal of two NI Act cases, the operational creditor got issued a demand notice dated 11/3/2019 for an amount of 50,17,589, for which the operational creditor sent a reply notice dated 19/3/2019 denying their liability. Thereafter, the above company petition was filed by the operational creditor on 20/08/2019, claiming an amount of 50,17,589. Decision of the adjudicating authority. The operational creditor is not entitled to charge interest. However, it was observed here that the operational creditor filed the present company petition specifically admitting in part 4 of the petition that it has received rupees 10 lakhs from the corporate debtor, which has been appropriated by them towards interest by once again rising dispute that they are entitled to charge interest. Therefore, it is very clear from the conduct of the operational creditor that they are relying on admission of liability of 39,35,086 in the balance sheet of the corporate debtor for the purpose of saving the period of limitation for filing the above company petition, and the same breadth demanding the entire amount, ignoring the admission of liability in the balance sheet of corporate debtor while in comes of to recovery. Therefore, it is very clear that the operational creditor is approbating and reprobating with regard to their claim, and thus there exists a dispute between the parties regarding the exact claim. However, the operational creditor got issued demand notice calling upon the entire amount of rupees 50,17,589, ignoring 10 lakhs payment received by them by hitting a self goal and created dispute by themselves as per their own case. Thus, the demand notice issued to the corporate debtor itself is not correct. Thus, it is very clear from the conduct of the operational creditor that they have not approached this tribunal with clean hands and using IBC as a recovery proceedings. Therefore, the aforesaid reasons, this bench is of the considered opinion that there exists a pre-existing dispute between the parties with regard to the exact amount of liability, and present company petition needs to be dismissed on that score. Accordingly, the above company petition is dismissed.
So fine, it is for interest it is, and when there is no written communication, you cannot claim interest. That's all.
Yeah, ma'am, particularly, they have also mentioned that, in their petition, they have admitted having received 10 lakh. So that's why the bench has talked about creating a, hitting a self goal, that you are raising a demand notice for 50 lakh. On the other hand, you have received 10 lakh, which you
10
have
lakh.
appropriated on your own. So there were various anomalies, I think, in this petition.
Yeah. Yeah, go ahead. Umesh.
Yes, ma'am. RS Refineries versus Mr. Supriyo Kumar Chaudhary, liquidator of JVL Agro Industries Limited. Purchasers is not entitled to claim compensation for breach of contract in liquidation sale. The order was passed by NCLT Allahabad bench on 9th August 2023. Facts of the case: the liquidator issued a public notice for sale of standalone assets of CD for e-auction. The liquidator announced the applicant as successful bidder with the highest bid of 12 crore 60 lakhs. The letter of intent was issued to the applicant along with bank details to provide balance amount. The liquidator via an email demanded outstanding balance along with an interest of 12% per annum of rupees 12 crore 40 lakhs 1,128.77 within the period of 90 days from the date of LOI. The applicant by letter requested the respondent to cancel the e-auction and refund the EMD amount deposited by him along with damages, and inform the liquidator that due to non-supply of oil within the time frame, applicant has incurred a huge loss in delivering the oil to other suppliers on time. Moreover, the quality of oil has also depreciated, which cannot be accepted. Decision of the adjudicating authority: a pursual of the letter of intent clearly states that the balance of sale consideration shall be paid within a period of 90 days, and the letter of intent and the e-auction process information document shall be subject to such orders as may be passed by this tribunal or any competent court. Therefore, in the view of the aforesaid judgment, we are of the considered opinion that the applicant is not entitled to claim compensation for breach of contract committed by him. The prayer made in the present application for directions is to be issued to the liquidators to refund the EMD amount of 96 lakhs and award compensation for the loss incurred by him is thus not sustainable. Therefore, we are not inclined to accept the prayer made in the application. The liquidator is directed to take immediate step forthwith for auctioning the assets of the corporate debtor under reference afresh in accordance with law and file the status report within a period of 4 weeks from the date of this order. The IA was dismissed.
So here, ma'am, what two things I think the bench has tried to convey, that as far as I could notice, one is that they have said that it was very clearly written that this information document, auction process document, is subject to orders passed by the tribunal or any competent court. So if there is any delay in the process, that has already been taken care of by the process document, because this person claimed that there was delay in handing over the oil due to certain delays in the legal process in between. And secondly, something which is not captured here, actually the bench also relied on a judgment of NCLT Delhi in the case of West Coast Infra Projects Private Limited, wherein they have categorically held that it has been quoted in this order also, that Section 74 of Indian Contract Act 1872 has no application in the case of auction conducted by the liquidator under the IBC liquidation process regulations. And when the clauses of tender document clearly empowers liquidator to forfeit the EMD / any payment on default by the H1 bidder, no exception can be taken to the action of the liquidator in cancelling the sale and forfeiting the amount deposited by H1 bidder. So, relying on this judgment further, I think the bench has taken this decision that there can be no question of any compensation or refund of the EMD amount. This is my take on this.
Exactly. In fact, here the successful purchaser has also pleaded that the quality of the oil which he has purchased by way of winning the auction as a successful purchaser has deteriorated. Therefore, he is not interested in going ahead with it. Even in that situation, NCLT said if you do not honor the payment, then the liquidator is well within his right to forfeit the EMDs as per the e-auction process memorandum.
Right.
Yeah, and when e-auction happens, if they want, they are also provided all opportunity to get the information and all that. Before that, they should have taken care. And if later on they realize it's their business, their mistake as such, they were not able to gather the information required to purchase by them. Right? This was
correct. In fact, madam, liquidator is also obliged to allow inspection.
Yes,
Yeah.
that's
Absolutely, yeah.
And they should have asked, they wanted to check the quality or anything, they should have taken care. If they are not asked, or if they have checked, then they are bound by that. If they are not asked, then also they are bound by their own action on that.
Correct.
It's very good this here that liquidator is protected, that he has taken care properly.
Right.
Absolutely.
Thanks. Yeah, Roshi.
Yes, ma'am. State Bank of India versus Shri Kailash Chandak. When no cooperation by personal grantor, there is no requirement to summon the meeting of creditors, and the creditors shall be entitled to file an application for bankruptcy under Chapter 4 of IBC. The order was passed by NCLT Jaipur bench on 8th August 2023. Facts of the case: the RP has made several communication with personal grantor or debtor who did not respond. RP noticed that personal grantor or debtor was appearing online repeatedly. Therefore, RP requested him to respond, but RP did not receive any reply from the personal grantor or debtor. Hence, in view of the above, it appears that the personal grantor debtor is not willing to submit any repayment plan. Hence, the RP has not received any repayment plan from the personal grantor or debtor. There was no requirement to summon the meeting of creditors. RP has prayed that this adjudicating authority may kindly pass appropriate order under Section 114 of the Code that the creditors shall be entitled to file an application for bankruptcy under Chapter 4 of the Code. Decision of the Appellate Tribunal. The adjudicating authority held that no repayment plan has been filed as personal grantor or debtor did not cooperate with the RP. Even he did not respond to the calls made by the RP. In its report under Section 106, RP has submitted that due to non-cooperation of the personal grantor or debtor, no repayment plan could be filed. Hence, the meeting of the creditors also could not be conducted. Since in this matter, personal grantor or debtor has not come forward to cooperate with the RP. Hence, the only option left for the RP is to file an application for bankruptcy under Chapter 4. This application is allowed, and creditors shall be entitled to file an application under Chapter 4 of the Code.
So again, ma'am, I think this gives a way ahead in many such cases where personal guarantors, where
they don't bother.
They don't
actually
bother.
Give clarity on the point that suppose it initiated and personal guarantor do not come, where is the question of the preliminary and anything. There is
Right.
clear direction for future process. of personal guarantor when they do not cooperate.
Yeah,
Correct.
when
So here, madam, it is more like if no resolution plan is there, then the company has to go into liquidation.
correct,
Here,
correct.
the only difference being that instead of a resolution plan, a repayment plan should be given. And the
Hmm.
repayment plan here can only be given by the personal guarantor.
Personal guarantor himself.
Personal guarantor.
Personal guarantor did not come forward, so adverse inference should be drawn that he is not in a position to give.
Position or willingness or whatever you say.
Correct.
Correct. So
No, very good,
that
Simri,
said,
you are
madam,
right.
nowadays no admission of the personal guarantor matter happens. Like for instance, the RP gets appointed, and RP is under obligation to submit a report, and thereafter reply is invited from the personal guarantors. Then arguments are supposed to happen on the merits of the case, so that if the court is convinced with the merits, then the matter is technically admitted. Admission order is passed, something similar to a CIRP admission order. So nowadays, at least the NCLT Mumbai, NCLT Ahmedabad are not going ahead, since there is a constitutional challenge to the certain provisions governing the personal guarantors.
Right.
Despite the Lalit Kumar Jain judgment,
Right.
there is certain other challenges on a different ground, which is pending, which is at an advanced stage. So therefore, no admission of the matters are happening here.
Right, and many creditors are not taking at present steps since it is remaining pending at the NCLT stage. So many are not initiating also. They are
Correct.
all
Because in
waiting.
any case, admission is not happening.
Yeah. Rosi, go ahead.
Yes, ma'am. Srinivasa Rao Ravinuthala RP Samyu Glass Private Limited. Central Excise cannot be treated as secured creditors under IBC. The order was passed by NCLT Chennai on 2nd August 2023. Facts of the case: challenge in this appeal is to the impugned order passed by the NCLT Hyderabad bench, allowing the application preferred by the resolution professional of the corporate debtor seeking approval of resolution plan of Rekanaiki agencies. The appellant challenges the approval of the resolution plan on the ground that the corporate debtor owns 22 crore 60 lakhs 32,948 towards the default in payment of central exercise duty, interest and penalty as per central exercise return filed with the appellant department. As per the resolution plan, only 0.13% has been earmarked towards government dues, and financial creditor is getting 44.5% of claim amounts, and the other operational creditor are getting 0.51% of their claim amounts, which is stated to be unfair. Decision of the appellate tribunal. In the instant case, this tribunal do not find any such irregularity in the provision of resolution plan as specified under section 32 of the code. Additionally, the tribunal is quite alive and cautious about the fact that the resolution plan was fully implemented and the successful resolution applicant had made payments amounting to 35 crores 25 lakhs to all the creditors, and almost 2 years has passed since the approval of the resolution plan, and this tribunal does not find any tangible and sustainable reasons to set the clock back at this point of time. For all the foregoing reasons, this company appeal is dismissed accordingly with no costs. The connected pending interlocutory application is, if any, are also closed.
This one is more of a delay, delayed filing also, apart from the well-settled position, of course, about the treatment of operational creditors, so that we are all aware of. But I think moreover in this case, the plan was already approved, 2 years has passed. I think the plan was fully implemented also. So at a very, very belated stage, this IA was filed and has been dismissed on merits, of course.
Correct. So, yeah, in fact, even as per the Rainbow Papers judgment, not each and every statutory dues are deemed to be the secured creditors.
Absolutely, yeah.
It has to be seen in respect of the governing statute. While Rainbow Papers judgment was passed in context of the GVAT, wherein the Supreme Court said that GVAT is a secured creditor, uh, Honorable Inclad has passed orders wherein they say that MVAT is not a secured credit because MVAT does not enjoy such status by virtue of its governing statute itself. Now, I believe it's my personal view. Now, this controversy is put to rest by virtue of Honorable Supreme Court's judgment in the matter of Raman Ispat Private Limited, wherein Rainbow Papers judgment is also considered. And court says that the statute makes a conscious difference between the secured financial creditors who are other than secured statutory dues also. And thus, now I think the muddy waters are becoming more clear by every advancing day. So I believe the Raman Ispat judgment holds the field.
Correct.
Thank you. Thank you.
Correct.
Due to the recent date, you can say overriding impact kind of say.
Yes.
Yeah. Thanks for your comment. Yeah, Joshi.
Orders passed by the disciplinary committee.
Okay, so now we are taking the orders passed by disciplinary committee. Okay, please.
Yes. Yeah. Contravention 1. Improper conduct of auction process. IP has conducted 3 rounds of auction to sell the CD as ongoing concern. However, all 3 attempts to auction to sell the CD as going concern failed. The board has observed that instead of 7 days, time between notice of auction and auction dated proposed by the IP in the first SCC meeting, he provided only 2 and 3 days respectively between the notice and auction as per the auction notice hosted on the board's website. His conduct of keeping the date of submissions of EMD as the same as the date of notice and giving only 2 days to participate in the auction process made the process infractious, resulting in unwarranted reduction of the reserve price. Submissions made by the IP. The only window available to the liquidator was between 60 and 90 days from LCD for exclusive going concern sale. Therefore, he conducted expedient auction after due decision of the SEC. He submitted that as regards to the reduction in reserve price in the subsequent auction, the same was done in consultation with the conscious with the members of the SEC. Analysis and findings. In the view of the above, the DC finds that the liquidator has not conducted the second and third auction in an unfair and improper manner, which made the auction process infractious, resulting in an unwarranted reduction of reserve price. Contravention 2. Excess fees charged by the liquidator. IP as liquidator was fixed at 60% of table rates. He has not adjusted 16,88,850 already paid to him and support service provided to the liquidator while calculating his fees at the rate of 60% of table rates as he has been approved by the COC. He has included interest income earned against the fixed deposit in the name of CD as amount realized by him for the purpose of calculation of his fees. Submissions by the IP. He submitted that he and his supporting team has raised invoices for a total fee, which is in line with the calculation as provided to the investigation officer, and agreed to the fees of rupees 16,88,850 was adjusted from the total fees accrued. The decision of the liquidator to keep the monies in fixed deposit led to increase in the liquidation estate and helped meet the liquidation costs. Analysis and findings. On pursuit of records submitted by the IP, the DC accepts his submissions. Order, the DC hereby imposes a penalty on the IP of amount of equivalent 50% of his entire fee earned as liquidator. The DC also directs the IP that no fee shall be charged on such distribution of penalty among stakeholders.
Yeah, I think it's clear.
What is your view, madam, on IBV's disciplinary process?
See, we can't have any view. We have to accept what is the order, what it can say. Yeah, and we have to follow.
Less said, the better.
Yeah, we have to follow. Yeah, each IP try to follow all the process and try to do everything perfect so far possible. According to me, each IP tries. So that's why, this we started also including this disciplinary committee order. So we understand that what is expected, because many times it is subjective and certain judgment are taken, which is in a good intent, but it is not acceptable. Then we are knowing that boss, we should not behave in this way. That way we can get educated. And that's
Absolutely,
why
madam.
we are doing.
In fact, madam, one bone of contention, in fact, this is also endorsed by our Honorable Bombay High Court, is that, madam, a IBBA disciplinary committee is different from an appellate authority. Supposing something is said by Honorable NCLT, something is said by, if some conduct of the RP is not proper, then he may be right or he may be wrong in law. But whether there is a mala fide involved or not, that has to be seen. If there is mala fide involved, then of course consequences should follow. So we cannot paint all the RPs with the same brush. Uh, I may be say putting it little differently, madam. So if some RPs are involved in malfeasance, mala fide things, then of course consequences must follow. But if something is done under a genuine intention and genuine belief, and if a particular provision is prone to interpretation both ways, so one can be technically right and technically wrong. Simply because one is technically wrong, he should not be saddled with disciplinary proceedings, at least in my view.
Okay, thank you.
Thank you.
Yeah, I know it's everyday learning day for every professional. So we also try to learn maximum so far possible and improve ourselves as such.
Correct, madam, sir, because that way, madam, a lot of lower courts order are set aside by the higher courts, and their orders by the top court of the country, and their orders in the review. So it's a learning process for all.
Yeah. Thanks.
Thank
Go ahead, no?
Yes. Contravention, excessive liquidator fees. IP have not excluded liquidation cost while arriving at a fee based on the amount of realization, and further has calculated its fees based on the percentages given for first 6 months, whereas the sale has completed after a period of 1 year from liquidation commencement date. Submissions by the IP submitted the differences in the total liquidator fees is sum of rupees 55,510 only. IP submitted further that the AA extended the liquidation period on the basis of exclusion of 355 days and on the basis of aforementioned extension granted on the basis of exclusion of 355 days. The liquidator's fees has been calculated correctly. Findings, the DC takes a sympathetic view in this matter. Order, the DC hereby warns the IB to be extremely careful and ensure full compliance with the provisions of the code and regulations made thereunder in his assignments. Contravention 1, non-conduct of the CIRP proceedings. Contravention 2, non-submissions of CIRP forms with the board. Withdrawal of application cannot be taken as grounds to await the outcome of application for over a year to not conduct the CIRP proceedings. As to the second contravention, it is observed that no forms along with the enclosures thereto have been submitted by the said IP to the board on electronic platform of the board. Submissions by IP, he submitted there was no malified intent on his part from proceeding with the paper publication, and there was no intentional lapse on his part for not effecting the paper publication in Form A, since the process of withdrawal had commenced prior to the 3-day time frame as contemplated under regulation of IBBI. Order, in the view of the foregoing decision, the DC, considering the bona fide belief caused by email of the applicant, OC, DC takes a lenient view in the matter. DC wants the IP to be more careful in handling pending assignments, and he further directs to undergo pre-registration educational course.
So, for example, ma'am, this one, when we were talking about IBBI's, Advocate Anrit was wanting to know what comments we have on IBBI. So, as you rightly said, there can be no comments, it's their discretion. However, for example, here in this matter, which Urvashi just read out to us, they are clearly agreeing with his submission, it seems, and they know that there is no mala fide in this, because he has said that the withdrawal process started even before this 3-day period, which is given to publish Form A, after the order is uploaded. So in this case, for example, I mean, if to my mind, even receiving a so-called notice, because I am sure that you would have been asked for a written explanation and you would have submitted the same facts. So how did it reach the stage of DC? For example, one is a little strange for me. And secondly, even if it did, and after the explanation would have been submitted even in person and explained in more detail, even then asking him to go for a pre-registration educational course, despite knowing that there is nothing wrong apparently that he has done, sounds a little kind of strange for me. You can give your comments, if any, on this. But it is good that they've taken a view, at least, where they have not, gone for harsh punishment. But at the same time, the explanations seem to be quite apparently clear that there was no, nothing wrong on the part of the IP, because he would not have known what to do when withdrawal process has started immediately after the order was communicated, and he had communication to this effect from the operational creditor, apparently, who was the applicant, as well as from the corporate data site.
The same way, like here we understand now whether it is correct on his part not to advertise or to advertise. If he advertised, then also it's a wrong thing, because he is knowing that the withdrawal process is started.
Yeah, in
Right.
fact,
If he
madam, the same
advertised,
view,
then it is
madam, is also propounded by Honorable Inclate, madam, in one of his judgment, that an RP, by continuing to act, should not sabotage the CIRP or withdrawal process.
Right.
Yeah.
That's what 99%, ma'am, supposing he would have gone ahead with publication, he would have been probably pulled by, the adjudicating authority for, having some, I mean, wrong. Sorry to say, but all kind of words are used for having vested interest, in pursuing this matter.
No. But in this case, this helps us when we take this kind of, discussion, that we should first immediately write to IBB and say that we are not making advertisement and doing this, at least have that communicated. It is taken that why you are doing this action and why it is done. And if it is same way communicated to even the relevant people, that shows the intention of IP. At least we can learn this from this case.
Right,
that if
right.
you are not doing what you have to do, so that the discipline IBBI will take that yes, you are right, your intention was not bad, so we are not. So I think that itself we are learning from this case. So that is the reason what we have to learn from each cases.
I fully agree with you, ma'am. I think you are right. The learning to be taken from these cases that keep the regulator as well as the adjudicating authority updated on the action, why you have taken or why you have not taken. Submit a kind of report there and submit a letter here. I think it will come to your rescue if any such thing happens.
That evident that your intention is very
Correct,
clear.
correct.
And that helps to give the clarity to each authority. Let's put that way, that each authority also is very clear that your intention is clear. They need not doubt or anything.
Right. Agreed.
Yeah, Urvashi.
That's all, Urvashi, I think. You are done
No,
with this?
sir. Two more DC orders.
Okay.
No, sir, that's it.
Yeah. Okay.
That's it.
Madam, our conduct initiation of disciplinary proceedings have a long history of jurisprudence in our country. So that has to be also adhered to and seen into and looked into by the regulators.
Right. There is one question in the chat box. Their current trend of replacing IP and not appointment of the same IP as a liquidator? Because why IP should be replaced, your opinion? I think it's telling your recent recommendation by IBBI to replace IP as liquidator. This is your views is sought.
Yes. In fact, madam, this arises from a letter which is issued by the Honorable IBBI to, I believe, all adjudicating authorities. Now, the question is that, Madam, 34 subsection 4 and subclause B is an enabling clause which enables the board to make recommendations to the adjudicating authority so as to replace whether existing RP has to be replaced as a liquidator or not. In fact, Madam, this provision specifically says the reasons should be recorded in writing why a specific RP should not be continued as a liquidator. Only then an adjudicating authority is bound by such a recommendation of the board. Now, this suggestion or a recommendation, if I may put it as high as I can, is only in the form of a letter. This is neither a regulation, nor this is a circular, nor this is a guideline or a rule.
Thanks. I think it's a very vibrant topic and also it's recent. We really appreciate your view. And if there is there any other questions, or I think time is up. Any other questions from the panelists? Participants? They can unmute and ask, or otherwise we will close. I will request both the panelists if they want to put any view on the today's case or otherwise on the subject or anything they want to say a few words on the topic or.
Madam, I would only thank Mehta and Mehta Insolvency and Restructuring LLP for organizing this kind of a program to the benefit of the IP community on the whole. And it not just refreshes the knowledge of the participants, but also the panelists, if I may say.
Yeah, thank you. Thank you. Thanks a lot, Mr. Anirudh, for, I would say, Advocate Anirudh, for your time and really inputs, all very good inputs you have given and knowledge sharing by you. Mr. Devendra, you want to say anything or we can close it?
Yeah, not much, ma'am. I agree with the Advocate Anirudh that when you put us on panel, we also are forced to learn because we go through them to contribute constructively in this discussion. And of course, it is learning for all of us. We are all in this journey together. And the judgments, because you are organizing it on a regular basis every fortnightly. So these learnings, when they are discussed in this kind of a webinar and we talk to each other, so they are imbibed. So some of the decisions, for example, the one on the personal guarantor matter, extinguishment as well as personal insolvency matters. So once we discuss, I am sure we as panelists as well as all the participants would now not forget these kind of judgments, and they will help them professionally as well as us professionally. So thank you very much for organizing this. I'm sure it gives us a lot of knowledge and participation from everyone. Thank you very much, ma'am.
Thanks,
Thank you,
thanks
everyone.
everyone. Thanks, Mr. Devendra. Thanks all of you participants. And we will continue again. We'll come after another fortnight with the same series and we'll keep on continuing. If you have any suggestion, please let us know on the topic. We'll surely bring it. Thanks. Thanks a lot. Thanks, Mr. Anirudh and Mr. Devendra. Thank you.
Thank you.